Welcome to Laws 13013, Legal Professional Conduct, Topic 6, Duties of Representation. I'm Stephen Colbran. Topic 6 begins our examination of the third theme for this course, the lawyer-client relationship. The specific topic for this week concerns duties of representation. The reading for this topic is Isaiah Ross, Ethics in Law, Lawyers' Responsibility and Accountability in Australia, 5th edition, Chapter 8. This topic can be complex as it involves a conflict of the business imperative and genuine human nature. These come into direct conflict when considering whether to represent, for example, a repugnant client. After studying Module 6, you should be able to outline the rules governing the question of whether a legal practitioner can actually decline to accept a case. You'll gain an appreciation of the ethical dimensions of the problem posed by unpopular and repugnant clients. We'll be looking at comparing and contrasting the rules that inhibit lawyers from withdrawing from a case once it's been accepted, with the corresponding rules that give clients the right to choose and to dismiss lawyers. And finally, we'll be looking at assessing the claim that there's been a shift in legal professional practice from a service ideal to a perspective based on business imperatives. So, would you be prepared to represent a repugnant client, the consequence of which may be public disdain, professional isolation, and potential loss of future income? Would it be fair or just that such clients have no representation in the context of our adversarial system? When can you or your client terminate a retainer contract, and just what are the implications that flow from that termination? These are practical questions which will confront you in practice at some point. The lawyer-client relationship involves the following duties owed by lawyers to their clients. There is a duty to act. There is a duty to inform the client. There's a duty to obey instructions given by your client, even though you may think that they're wrong. There's a duty to be competent, a duty to preserve client confidentiality, and a duty to be loyal. Many of these duties are found in the Australian Solicitors' Conduct Rules of June 2011 and also the corresponding bar rules. The first rule that we're going to look at is the cab rank rule. This rule only applies to barristers. It does not apply to solicitors. So what is the cab rank rule? The rule is set out in two provisions of the Barristers' Rules, Rule 21 and Rule 22. Let's have a look at Rule 21. A barrister must accept a brief from a solicitor to appear before a court in a field in which the barrister practices or professes to practice if the brief is within the barrister's capacity, skill and experience. The barrister would be available to work as a barrister when the brief would require the barrister to appear or to prepare, and the barrister is not already committed to other professional or personal engagements, which may, as a real possibility, prevent the barrister from being able to advance the client's interests to the best of the barrister's skill and diligence. The fee offered on the brief is acceptable to the barrister, and that the barrister is not obliged or permitted to refuse the brief under Rules 95, 97, 98 or 99. So that's the basic cab rank principles. You can see there's a lot of ways for barristers to escape the implication of the rule, and we'll be looking at some of these in a little bit more detail. The second rule is in Rule 22. A barrister must not set a level of acceptable fee for the purposes of Rule 21C higher than the barrister would otherwise set if the barrister were willing to accept the brief, with the intent that the solicitor may be deterred from continuing to offer the brief to the barrister. So you can't escape by increasing your fees and then trying to deter a particular solicitor from offering you a brief. So there's a balancing act between the exceptions and limitations placed on those exceptions. Let's have a look at some of the critiques of the cab rank rule. Firstly, perhaps some of the exceptions first. The mandatory exceptions appear in Rules 95, in which there are 14 exceptions, and Rule 97, which deals with potential breach of confidentiality, and Rule 98, which deals with situations where a barrister might be double booked. There's also mandatory exceptions in relation to direct conflicts of interest, and also with respect to maintaining client confidences. Obviously, you can't represent a client if it's going to breach the confidence of another client or involve a conflict of interest. So they're mandatory exceptions. There are also a set of discretionary exceptions in Rules 99 through to 106. And these rules enable the barrister to decide whether a brief may be refused or returned. So you need to spend some time and go through those particular rules and make sure that you understand them. There are a number of arguments against the cab rank rule applying to solicitors, for example. That's always been one of the questions. Why should it just apply to barristers and not solicitors? The arguments are that the rule shouldn't apply to solicitors because there's a greater supply of solicitors than barristers, and therefore it's easier for a client to get representation. Secondly, solicitors acting as a sieve or a filtering device for unmeritorious claims, that they do that in any event. So they're the principles of why it shouldn't apply to solicitors. Some argue that it violates freedom of association. That is, the pursuit of individual projects and goals is integral to the attainment of personal happiness, and that this is that the whole principle violates freedom of association. What works for each of us, and accordingly the collective pursuit of our individualistic aims, is at most points likely to be the best method of maximising happiness. That a central manifestation of the right to liberty is the right to associate with people of our choice, that individuals are permitted to choose the company they wish to keep, whether in public or professional settings. And therefore we shouldn't be forcing barristers to accept repugnant clients. They should be enabled to take advantage of freedom of association. Another argument is that not all rights are accompanied by duties, that the right to legal advice does not necessarily mean that all barristers must act for a client when requested to do so. Lawyers are indeed the only people who can legally represent others, but not every lawyer must have his or her liberty curtailed to ensure that each person's right to be legally represented is observed. The last argument relates to economic expedience. There is at least one obvious advantage to this obligation that the cab rank rule places on barristers, in the sense that it insulates barristers from criticisms that they are in some way inflicted with the moral flaws of their clients. The cab rank rule assists barristers in Australia to take unpopular cases. Absent that rule, if you take the rule away, some barristers could be deterred if such appearances were generally construed by professional colleagues and the public as a whole as expressions of sympathy for the particular client's cause. So in that sense, the cab rank rule enables representation, but also provides an argument for barristers to say that the representation doesn't reflect their personal views, but rather a professional obligation. Let's take a closer look at unpopular and repugnant clients. Solicitors, as we've seen, may reject unpopular and repugnant clients. Barristers are subjected to the cab rank rule and also the rules 2, 4, 5 and 37. And you should look at those particular rules, 2, 4, 5 and 37. So who's regarded as a repugnant client? The answer to this question is an individual decision based on the client's goals and not necessarily the client themselves. The cab rank principle supports professional detachment. Representing unpopular and repugnant clients can attract public and peer disdain and affect incomes. So it's a difficult issue for a number of practitioners. If you look at it from the side of the defendant, a defendant facing serious criminal charges obviously benefits from the cab-rank principle in the sense that they can get representation, but it's important to note that they actually have no right to representation. So if they can't afford representation, or none is made available for them through legal aid, then they have no right to demand representation. There are 3 cases in the notes which I'd like you to spend some time looking at. That is McInnes and the Queen, 1979, 143 CLR 575. Dietrich and the Queen, 1992, 177 CLR 292. And the case of New South Wales and Canellis, 1994, 181 CLR 309. But the basic principle is that there is no right to representation. Let's now shift to looking at the duty to continue to act. The general rule is that lawyers contract and that they are required to finish the entire retainer. There are exceptions to this rule found in the Australian Solicitors Conduct Rule 2011, Rule 13. So let's have a look at Rule 13, which extends over 2 slides. Firstly, 13 says completion or termination of engagement. 13.1. A solicitor with designated responsibility for a client's matter must ensure completion of the legal services for that matter. So you're required to complete the matter unless, and then there's 4 exceptions. The client is otherwise agreed. The law practice is discharged from the engagement by the client. The law practice terminates the engagement for just and on reasonable notice. So for just cause or on reasonable notice. Or the engagement comes to an end by operation of law. Where a client is required to stand trial for a serious criminal offence, the client's failure to make satisfactory arrangement for the payments of costs will not normally justify termination of the engagement, unless the solicitor or law firm has served written notice on the client of the solicitor's intention a reasonable time before the appointed date for commencement of the trial or for commencement of the sittings of the court in which the trial is listed, providing the client has 7 days to make satisfactory arrangement for payment of the solicitor's costs, and given appropriate notice to the registrar of the court in which the trial is listed to commence. So there is, if you satisfy those conditions, the ability to remove yourself from a client who refuses to pay your fees, but there are set requirements before you can do that. It's a balance between the administration of justice and also your personal interests or those of your firm. The last part of Rule 13 is 13.3. This says that where a client is legally assisted and the grant of aid is withdrawn or otherwise terminated, so that legal aid is no longer available, a solicitor or law practice may terminate the engagement by giving reasonable notice in writing to the client, such that that client has reasonable opportunity to make other satisfactory arrangements for payment of costs which would be incurred if the engagement continued. So the bottom line is that as a solicitor you're not forced to work for nothing. However, there are some requirements for you to extricate yourself from a situation in which a client can no longer afford to pay your fees. So you need to be very wary of these provisions and make sure you follow them to the letter. So what happens if you breach your duty to act? The consequences of breach may include disciplinary action, and that's really rare. Being sued for negligence, which is also rare. More commonly would be loss of payment for work performed prior to the breach. And another possible consequence would be a new trial if the client has to proceed without representation. So it's important that you comply with the requirements of the rules in relation to termination. particularly if fees are not paid. Let's focus again on barristers, this time in terms of returning a brief. Barristers often double book cases due to court listing procedures, adjournments and settlements. It's quite common for matters which have been prepared for trial to settle on the day of the trial. Or not necessarily trials, but certainly civil matters. There are some restrictions to this found in the bar rules. A barrister must not return a brief to appear in order to accept another brief to appear, unless the instructing solicitor or the client in the first brief has permitted the barrister to do so beforehand, after the barrister has clearly informed the instructing solicitor or the client of the circumstances in which the barrister wishes to return the brief and of the terms of Rule 102 and Rule 104. Rule 104 states that a barrister who wishes to return a brief which the barrister is permitted to return, because not all of them you are permitted to do so, must do so in enough time to give another legal practitioner a proper opportunity to take over the case. Here again you see the balance of public policy. You don't want cases coming before the courts where the practitioners are all prepared. Obviously people need time to prepare their cases. You should study Barristers' Rules 95 through to 106, which we've already previously mentioned, which deal with the following factors. Briefs which must be refused or must be returned, so these are ones you cannot do. That's set out in Rules 95 to 98. And briefs which must be refused or returned at the discretion of the barrister. It's not must, but may. Briefs which may be refused or returned at the discretion of the barrister. And they're set out in Rules 99 to 106. So take the time and read those provisions and summarise them. So let's consider now the client's right to choose and dismiss counsel. Clients are entitled to dismiss lawyers, for example, for loss of confidence in them. Clients must pay for the work done or risk a lien being placed on their files. Solicitors' Rule 15 allows solicitors a lien over essential documents for unpaid costs. If the case is sound, a lien may not be granted by the court. There is also the risk of negligence suits being brought by the client. In terms of what documents are owned by clients, you should read the case of Wentworth and Montfort, 1988, 15 New South Wales Law Reports at 348. There's also a right for the client to choose counsel. Clients have a right to choose counsel. In Collins against the Queen, 1976, 8 ALR 150, the High Court affirmed the principle that parties to civil or criminal proceedings have the right to represent their own case. So that's for self-representation, but they also have a right, of course, to choose their own counsel. Typically, they would do so on the advice of their solicitor. What about reasonable prospects of success? In this case, it's important to look at Barristers' Rule 63. A barrister must not allege any matter of fact in any court document settled by the barrister, in any submission during any hearing, in the course of opening address, or in the course of a closing address or submission on the evidence, unless the barrister believes on reasonable grounds that the factual material already available provides a proper basis to do so. So, it's important that your case has reasonable prospects of success, and that you as a barrister must believe on reasonable grounds that the factual material already available provides a proper basis for you to make your court submissions. So obviously you need to think about this notion of a reasonable prospects of success. In some jurisdictions such as New South Wales, there are specific provisions which make it unethical to bring a case without reasonable prospects of success. Queensland, it seems, doesn't have a particular rule in relation to that, but it certainly is something that you would, in your professional capacity, advise a client not to proceed if there was no reasonable prospects of success in relation to the particular litigation. This concludes Topic 6, Duties of Representation. Next week we'll be looking at topic 7, communication and control.